And we are live. This is the Baldani Law Group. As always, we're doing Friday Legal Mailbag. I'm here with my partner, Abe Mashney. And today we're going to be covering a grab bag of questions that you guys have about the law that we've received. So we've got our questions here. I will note today that our Facebook counter is down. We've got some new networking equipment. But as always, you can go and you can like and you can... See, it's kind of doing that. You can share, and you can tell your friends about us. And if you have anybody you know that needs help with a criminal case or a family law case or a personal injury case or really any type of case, we can get you what you need, the help you need. And if we don't do it, we'll make sure you get the right lawyer. So without further ado, let's go to the intro. All right, and we are back. Like I said, we're here doing mailbag, grab bag, just a little bit of everything today. So we're going to start off with a quick question for Abe. So Abe, I know you're not an immigration lawyer. You don't practice in front of the immigration court. But could you tell me a little bit about how criminal cases and immigration kind of interact, how they kind of go together, and what will happen to somebody's immigration status if they get arrested?
Sure. So generally speaking, a criminal case can have extremely detrimental aspects to any type of immigration situation that a person is in. If you are not a citizen and you are committing crimes in this country, the government frowns upon that, and they're looking for reasons to deport you. And so the quickest way to do that would be to get incarcerated, and because then ICE they may put a holder on you. You may have a separate...
ICE is what, Abe?
The immigrations
and customs
yes,
enforcement. So yeah, it's a federal law enforcement that enforces immigration law, and you don't just and it's not really all non-citizens. It's particularly people that are have no status. So there's some people that'll be lawful permanent residents, green card holders. There'll be people that are on visas. It's a really really complex area. But I think at the end of the day, the advice is, if you are here and you are not a citizen, you need an immigration lawyer and a criminal lawyer.
Yes. Routinely, we will refer people to immigration attorneys and have them write a summary as far as what they think, or if a certain charge, if we've been given an offer, we want to look to see if the immigration attorney, if that is going to be a deportable offense, or if it's going to detrimentally affect their application, or if they're a visa applicant or asylum applicant. We're always wanting to... There's a law, or there's a case. It's a famous Supreme Court case. It actually came from Kentucky. It's called Padilla, and that, as a criminal defense attorney, we have to make sure that we're giving our clients the knowledge and the information as far as how their criminal case is going to affect their immigration status.
Okay, so moving along, next question: can I change Kentucky criminal defense lawyers if I'm unhappy with the lawyer that I have representing me? So, if you're in a case already and you've already started with a lawyer, Abe, do you think it's possible to get another lawyer if you want a second opinion, or maybe you just want to start all the way over?
Yes. So there are a multitude of complaints that an individual may have about their attorney. They may just not see things the same way. If you're fighting a criminal case, you need to be on the same page with the client. The client needs to be on the same page with the attorney. They need to trust the attorney, and just kind of all working toward the same goal. And so the biggest complaint that we get is, I can't get a hold of my lawyer, or my lawyer won't return my phone calls. And so that's a number one thing that we get on people that already have an attorney.
To be clear, that's not a complaint about us that we get.
Correct.
That's
yes.
a complaint that we get about other lawyers. But, and there are lots of reasons that can be. But go ahead. Sorry.
Right. No, so that is people calling us and wanting a second opinion, or maybe wanting to switch, and so that's why we make a huge emphasis on client communication, being available, giving clients the cell phones, and just being able to be there for the clients, because it's not a 9-to-5 job.
Sure. So, are there ever times that you can't replace your lawyer? Have you ever seen that happen?
On the rare occurrence, an individual may want to change their attorney. It may be very close to a trial date, and in those situations, the entire case is going to get backlogged. It's going to kind of start from scratch, because once you have a new attorney, or once you get a new attorney, especially in a criminal case, things start from ground zero, and that attorney has to get read up on the evidence and talk to the client, strategy, and all that stuff. And so there may be a situation where a judge will say, nope, you're going to have to keep the lawyer you have. We're not starting this over. And but for the most part, you are able to get a new lawyer.
Okay, great. Abe, what's the next question? I think I'll field this one.
Sure. So should I take a plea bargain if I'm offered one?
Oh, this is an easy question. Maybe. So
Depends.
you really don't. Yeah, you really don't know. It depends. And the reason for that is there's so many different factors that go into every case. Some offers are offers you can't refuse. Some offers are worse than what you're going to get at trial, or you may be completely innocent and you shouldn't take any offer. Those sometimes innocent people even choose to plead guilty. Not a lot of my clients, but there certainly are reasons out there, with the sentences being as high as they are, with the penalties being what they are, that innocent people do plead guilty, and I've seen it. Ultimately, the decision to plead guilty or to accept a plea bargain is the client's decision, not the lawyer's decision. But I always encourage people, if they are innocent, to fight the case to the end. But at the end of the day, you can't say, yes, you should take a plea bargain, no, you shouldn't take a plea bargain, unless you know what the bargain is and you know what and the case has been evaluated and worked up. And you can, with some specificity say, well, I think this is what would happen. You'd go to trial. Now, if the offer is better than what you'd get if you went to trial, and most likely, and in all likelihood, then you probably should consider the plea bargain. But even then, it has to do with what your tolerance for risk is. If you're willing to accept that, hey, it's a 1 in 100 we win, or you can take this probation offer. Some people might say, I want that 1 in 100 chance that I completely walk. I don't want to be on probation. Now, that's probably not the decision I would make if it were my case, but I've never been in that situation. I don't know. And there can be extenuating circumstances. So maybe I'll lose my license, whether it be a driving license or a nursing license, a doctor's license. Maybe I'll lose my job, And I'm willing to go to the mat for that, because the potential penalty may not be so great. I've seen people try DUI cases, in particular CDL drivers, where they're almost certainly loser cases, but they can't afford to lose their CDL. They lose their livelihood. So in those types of cases, you may be willing to take a different risk than you otherwise would be. So, should you take a plea bargain? It depends. So next question we've got is, what is the difference between probation and parole? Abe, you think you could take that one?
Sure. So at the conclusion of a criminal case, when there is a conviction, the judge is going to have to determine what that sentence is going to be, whether it be probation, and that's going to be in lieu of actually going to prison. And so if you're granted probation at your sentencing hearing, then that means that most likely it may be a condition that you serve a little bit of time, maybe 30, 60, 90 days, but for the most part, you're going to be serving your sentence while out on the streets being supervised. And so there's a litany of conditions that somebody may have as far as probation. You may have an officer, you may be drug testing, you may have to do community service, work, or be in school. And so those are supervised probation. You'll have a probation officer. If you are sentenced to prison, and so if at the sentencing hearing you are not granted the privilege of probation, then at that point you become an inmate and you become Department of Corrections. And so then you serve your time in the prison, and our sentencing laws here in Kentucky, they have different eligibility statuses. And so some crimes you're eligible 15% until you're eligible for parole, or you may be 20% or 50%, or for violent offenders, it's going to be 85% until you're eligible to go to the parole board. Now, the parole board is you go in front of them, and they will decide whether to let you out of prison. And at that point, they will. It's similar conditions as far as you might have to drug test. You'll get a parole officer. You may have to work or do maybe a substance abuse assessment.
Mm-hmm.
But the huge difference is between probation and parole. The time that you are spent on parole goes toward your full sentence.
You get your street credit.
You walk it out on the street.
Walk it on the streets.
Yes.
I want to give a shout out to Katie Webster, who's watching at home. Congratulations. And I want to give another shout out to Eric Ray for writing in with a question. We're going to get you in just a second, Eric. Don't worry. So anyway, continue, my man.
All right. So, but on probation, that time that you've been sentenced, that time is hanging over your head, is what they like to say. So, let's say you're sentenced to 1 year prison, probated 5 years. And so you're going to have to be good for 5 years. You're going to have to comply with all of your conditions. But if you mess up and if you violate that probation within that 5 years, you still have that 1 year hanging over your head that you might have to serve. Whereas if you're sentenced to prison, you're granted parole, then you walk that time off, and then so you're completing the sentence outside of prison.
Okay. And so I think that really gets it. So let's go to Eric's question, which is, if I'm innocent, why shouldn't I talk to the police? Which is actually one we had already had on here, which was going to be, if the police invite me to the station to hear my side of the story, should I go? And so I guess I'll start by answering it. If you're innocent, why shouldn't you talk to the police? Well, you might say something that incriminates yourself, and even if you're completely innocent, you could say, the car that I know that I saw the crime, I was a witness to it. The car that went by was maroon, and then another witness could say it was red. So that's inconsistent, right? And when you have inconsistent statements, that sometimes can cause to incriminate yourself. And so you wouldn't want to put yourself in a situation where you even innocently create evidence against yourself, and by being inconsistent, even on some small fact like that. Now, I don't think the police would arrest on that example. But the point is, even on something as innocent and small as that, you can be hurting your case by making a statement. And if you do invoke your Fifth Amendment right, that can't be used against you. And so it's much more the case that I've seen, anyway, in my experience, that when people do invoke and they do remain silent, they ask for an attorney. And to be very clear, if you are accused of a crime, in almost all circumstances, I would encourage you to say, I can't talk without my attorney here. I ask to remain silent. And if you do that, the interrogation just has to stop. That's it. Now, that's if you're in custody. And that gets into kind of some of the weeds about Miranda, but ultimately, most police officers that I've seen, at least, will honor that. Now, I've had cases, including I had a murder case, actually, where the defendant was being questioned, and he actually asked for the lawyer, and they said, you could have a lawyer as soon as you get done answering our questions. And that statement got thrown out, and that we actually ended up getting a good result in that case, though he was not guilty in my view. Nonetheless, I think that it's very rare when a defendant should choose to talk to the police, and certainly extremely rare, if not 100%, they should never talk to the police without having a lawyer present. So, Abe, anything else you want to say about that?
So, even if a person is 100% innocent, didn't do it, not at all, and police asked to speak with you, it's going to be an extremely stressful situation. So they're going to be recording you. They are going to be, you might have to go to police headquarters, sit in a room, and what you're going up against is a trained professional interrogator.
They get certificates on having learned how to interrogate people.
Right. And so most of the people that go in that room have not received the training that they have received, and so they're at inherently a disadvantage. And so they can lie to you, and without fault. They can, pure as day, tell you false information.
Yeah.
They can. You hear about false confessions all the time.
It's a real thing. I actually have seen 2 capital murders. People get charged with them and then have them dismissed in the time I've been here because of false confessions. Which is crazy to think that they were coerced effectively into confessing to something they didn't do. Most people think I would never admit to something I didn't do, but it has happened. I've seen it.
And so everybody's memories are slightly different, and you can think 100%. I remember this clear as day, and if somebody else remembers it slightly different, then the police might think that their testimony is more credible than yours. And so in that fact, they might think in their investigation that you're lying to them, which would obviously hurt your case and get you in a position that you may not have been in if you didn't make that statement.
Okay. So next question we've got is, can I be charged with the DUI after having only one drink?
Take it.
the answer to this question is depends on what your drink is, I guess. If you only had one bottle of bourbon, then the answer is yes. But, most people, when we talk about drinks, we're talking about a standardized kind of unit. And that's, one 12-ounce beer that's about 5% alcohol, one 4-ounce glass of wine that's about 12% alcohol, or one 1.5-ounce shot of 80 proof liquor. And so for most people that have normal metabolism within normal bounds of weight and things like that, probably would not be able to get convicted of what we call DUI or operating under the influence of alcohol, and what we call that in Kentucky, because you have to have a blood alcohol concentration of 0.08. However, there's another statute if they don't want to proceed under that statute where if you're just under the influence of alcohol, say you're somebody that has a genetic condition that causes alcohol to affect you much more greatly, or maybe you're having alcohol in concert with some sort of prescription medication or over-the-counter medication, even to where, say you take a Benadryl or something that makes you sleepy, and then you have, your one shot of bourbon, or maybe your one shot of like overproofed bourbon, right? Like 140 proof bourbon or something like that. Maybe you could be convicted of DUI in that circumstance. Now, you certainly could be convicted of DUI after having one drink if you were under 21, because the limit for under 21 DUI is 0.02 nanograms per milliliter alcohol in breath alcohol concentration. So to answer the question is, you're probably not going to be convicted of DUI after having one drink, but it is conceivable. And so you should never drink and drive. Don't mix the two. Don't have one drink and drive. You just shouldn't. It's the safest thing. Even one drink can impair you, can slow down your reaction time, and certainly 2 or 3. And so Abe and I did an experiment with craft beers about, 7, 8, 9 months ago, in which we drank beers, and we saw that, 3 strong beers got us right to the legal limit. So
still need to do the bourbon one.
We're going to do a bourbon test. Write in the comments if you want to be considered to be in the bourbon test. I think it's going to be a lot of fun. We're going to do it here at the studio, maybe sometime in February, because we're going to be cold and we're going to need bourbon because we're bored and depressed, sad, the sun not being here. But in any event, we're going to have that bourbon test coming up. But really, probably not after one, but it is possible.
I agree. It's a situation where if you take that one drink, then it may be on your breath. And if you get pulled over, an officer is going to potentially smell that and automatically think that you've had more, just because their training experience, if that's what they smell, and then whatever side effects.
Hey, shout out to Brent Cox. Shout out to Andrew Hager.
What's up?
What's up, Andrew Hager? All right. Sorry, Abe.
No problem. All right. So next question. What does unsupervised probation mean in Kentucky? It's pretty simple. You, instead of going to jail, you are granted the opportunity for probation. And unsupervised probation means you're not going to get a probation officer. You're not going to have to drug test. You're not going to have to pay the probation fee. Well, actually, do you have to pay the probation fee?
I think in some counties you would. So it depends if you're on like a kind of a conditional discharge, which would be where so long as you don't come back before the court, you don't have to do any time. But in some counties, you have to pay a CAPS monitoring fee. Like quarterly, They'll do a records check. So I think it's going to depend on county by county in the context of misdemeanor probation. And felony probation through the state, I think that you still would be paying the $10 a month.
Gotcha.
But I also got to give a shout out to my mom who's watching. So shout out to Mom. I love you. And thanks for watching.
So, the main thing with unsupervised probation is you cannot pick up any new offenses. You cannot be found guilty of anything over than a traffic ticket, and because that would violate you, and you would be facing a probation revocation hearing in which you could potentially serve some time.
Okay, so ultimately, if you're on unsupervised probation, don't pick up any new charges. You're going to be fine.
Simple as that.
You're not reporting. You're not drug testing. Just don't do anything. Don't get caught. Don't do anything. Period. Okay. So the next question we've got is, can the bail amount be lowered if a judge sets the bail too high? And the answer is yes. So we frequently have bond hearings, bond arguments for people that are in jail. And ultimately, in Kentucky, there's a statute that governs this. It's 431-525. And what it says is that there are several factors that the court needs to look at when deciding what the bail should be set at. Those include kind of the ability of the defendant to pay, the whether or not it's enough to ensure that the person returns to court, they need to make sure that it's not so high as to be oppressive, and they need to make sure it's commensurate with the nature of the offense and with the reasonably anticipated conduct of the defendant. All that is to say is that the bond is ultimately going to be a function of what your record is and how serious what you're charged with is. In my experience, those are really the two factors that kind of override everything. Abe, would you agree with that?
I agree. The main thing is criminal record and what the charge is. Those two things, and the pretrial report is going to play a part in it. The pretrial officer is going to interview you, give it NCIC, which is a law enforcement background check, and with that information, the judge is going to make a determination as far as what that bond amount is. And what we regularly see is people call us all the time and say, "Hey, can you get in this case? I just really need a lower bond." Well, unfortunately, that's just not how it works. Once we get into a case, the judge is going to expect us to stay in the case, and so
and we expect to stay in the case. I don't want to get in a case if I'm not going to finish it. That's ultimately, if I take the time and the effort to get into the case, I want to make sure that we can finish the case. And one interesting thing right now is that, and this is kind of a lot like the federal system. We're talking about state court right now as far as those factors, but the federal system, you either basically get released or you get detained. It's more rare to see actual cash bond in the federal system, and we may well go to that in state. Right now, there's a big bail reform act going on in Frankfurt, a debate about it, and ultimately there's going to be some pros and cons like there are to anything. But we may be getting rid of cash bond in the next year or so, and it'll be interesting to see if that impacts how many people actually get released, when ultimately I feel like these determinations that judges are making are more or less the same. Should a person be detained? Is it so serious? Is their record so bad? They're kind of already making those determinations and setting the bonds. So really what it will do is potentially just detain more people that have the ability to pay. Obviously, I think that there are too many people that are detained pretrial. We're talking about people, and to be clear about bail, we're talking about money that is put down to ensure that the person returns, a person that's presumed innocent that hasn't been convicted yet. Bail is not pay and get out of jail after you've been convicted. It's pay to get out and fight your case while you're waiting to go to trial. And we have far too many people in this state, in this country, that are detained before it's been determined that they're guilty. And ultimately, I hope that whatever Frankfurt's passing is going to let more people out. So, because one of the biggest predictors in whether or not you have a good result in your case is, were you out on bond? And that's because some of the factors we'll talk about if we talk about what you should do preparing for sentencing. But it allows you to get out and get a job, get into rehab, work to ameliorate, to lessen whatever the negatives that have happened, pay restitution, whatever it may be. And so, I hope that we see a good Bail Reform Act. Obviously, skeptical, but we'll see. So
I just want to talk about how important it is to retain an attorney, or to have your attorney be able to be prepared for any bond arguments. And so sometimes sometimes people will wait and maybe retain us. I've been retained 15 minutes before court, and we have to run over there and race and get over there as quick as possible. It's always best, and it's always better to retain the attorney as quick as possible and give them as much time as possible. Here, I'll give you an example. So, unprepared attorney, judge, I see the bond is at $10,000. Would you consider a $1,000 bond or a 10% for my client? That's.
Do you want me to do the prepared attorney?
Sure.
Your Honor, I'm here on behalf of my client, Mr. Abe Mashney. I'd like to bring up the issue of bond. It appears that he's been assessed as a low risk at 2 points. He has no prior failures to appear. He's got a good job. He works out at Baldani Law Group. I know I've talked to his employer that he still has his job and he can be there. I've talked to his family. They would be willing to post surety.
They're in the courtroom as well.
And they're in the courtroom as well, as you'll see if you would stand up, Miss Mashney. Thank you. And she'd be willing to take custody of him if need be. We could put him on the ankle monitor. We could put him on home incarceration. Just whatever it is. I know, having spoken with Miss Mashney, that she'll make sure he gets back to court. Is that about what you'd say, Abe?
World of difference.
So, moving on. Can I be credited for jail time if I have already served when I receive my sentence? So we're talking about those people that are stuck waiting for their trial in jail, those people that haven't been able to post bail. Do you get credit for that time, Abe, or does it just go away?
You do. You get credit for all time in jail while awaiting sentencing, and you get credited for that case. Where it gets a little tricky is if you have multiple cases going on at the same time. as far as what the time that you have spent in jail, where that goes. Usually it's the first in line as far as the cases are concerned. And so, but the simple answer is yes, you do get credit for all time that you've spent in jail prior to sentencing.
Okay, well, that wraps up our show today. Those are the topics we wanted to cover. I want to thank everybody for watching. As always, we are the Baldani Law Group in downtown Lexington. If you have any legal needs, give us a call. And we're down here at 300 West Short Street. You can always email me, brad@baldanilaw.com, abe@baldanilaw.com, or just message us on Facebook. If you're watching this, you probably have liked us on Facebook, and we can help you out. I'd like to give a shout-out to everybody that watched: Andrew Hager, Brent Cox, Katie Webster, my mom, Eric Ray, of course, for sending in a question. If you've got questions, leave them in the comments, and we'll do them next time. This is Friday Legal Mailbag. I'm Brad Clark. Abe, you got anything to say?
Have a great weekend.
And we out.